Moderator. Yeah, so we're gonna leave a small space for questions and answers after the presentation. I hope this works for you, Paul. And yeah, Andreas is gonna be the moderator, but we will be here in case, you know, anything happens or if she needs assistance or you. So thank you again, Paul.
No, I'm happy to do it. And I look forward to talking next week. I don't know if you saw the email I sent you this morning, but if you want to send me a Zoom link, that would work great for next Tuesday. That sounds terrific.
Oh, got it. Perfect. Okay. I'll write it down and I'll let you know after the presentation. So thank you so much again.
Absolutely. Just let me know when to get started.
Hello.
No.
Good morning, students and scholars. I'm Andreas Valdivar. I'm from the International Affairs Coordination. Now, shall we begin?
If you're ready, we can certainly start.
Thank you. Well, the National Autonomous University of Mexico, through the assistance of the Division of Postgraduate Studies and the International Affairs Coordination, as well as in partnership with Chicago UNAM, is delighted to welcome you to the second session of the seminar, Relevant Aspects of the North American Legal System. I must make the reminder that in order to gain access...
Acaba de sonar. Saco de deshace para montar en la camioneta.
Sorry. In order to gain access to the reunion, participants must enter the session with their full name. Additionally, if you have questions during the presentation, please feel free to leave them in the chat. There will be an indicated time to give them answer. Today's meeting will be approached the government structure and the Constitution of the U.S. The topic will be expounded by an expert in the subject. In this manner, I am pleased to introduce Professor Paul Lewis, Director of the Center for International Law. He is a graduate of Northwestern University with highest distinction as that of Yale Law School, where he served as senior editor of the Yale Law Journal and worked as a research assistant for Professor Drew Days III. Following graduation, Professor Lewis served as a law clerk to the Honorable David Nelson of the U.S. Court of Appeals for the Sixth Circuit, worked as an associate at Mayer Brown, and was Assistant General Counsel of Rotary International, where he did transactions in different countries. Besides, Professor Lewis writes primarily in the area of international bankruptcy and insolvency. He has also written and spoken in the areas of climate change and the lawyering of international commercial transactions. His articles have appeared in journals in numerous European countries as well as in Australia and the United States. He has also spoken at universities and conferences throughout Europe, Australia, as well as in the United States. Not only in recent years, he has served as a visiting professor at numerous institutions in France, Switzerland, and Italy, but also Professor Lewis teaches bankruptcy, property, secured transactions, and the negotiations and drafting of international commercial agreements. Finally, please welcome Professor Paul Lewis.
Well, thank you for the introduction. I'm very happy to be here, and I'm very excited about the burgeoning relationship between our schools. As mentioned, I have been teaching at the University of Illinois Chicago Law School, which previously was known as the John Marshall Law School, since 2002, I guess. And I'm the director of the Center for International Law, as well as a professor. And our center has traditionally focused on international business and international trade relationships. We have partnerships, around the globe, and we're very excited to be working with you in Mexico. So today, what I'm going to do is just give a kind of a broad overview lecture. Obviously, don't quite know the level of expertise or knowledge people have about the American system of government and the judicial system, but I thought I would just do sort of a very broad lecture about the nature of the legal system in the United States, and then talk a bit about one very significant area of it, which is the area of federalism, which I'll explain what that is. and talk about how sort of federalism is applied in a particular context. So I'm also very happy to answer any questions that you may have. So feel free to put them in the chat. I am not particularly good, I must say, on Zoom calls at keeping track of what's in the chat, but after I talk for a while, we can go back and look. So let's talk a little about the structure of law in the United States. So the United States Constitution is the supreme law of the country. It establishes a structure for the federal government. It distributes power among the various branches of government. It defines the rights and the liberties of the United States citizens. And any law which is passed by either the federal government or by any of the 50 states, which is not consistent with what's in the United States Constitution, is unconstitutional and is null and void. If you're not muted, perhaps you can do so. There's a bit of background noise. So let's talk about what all this means. In 1787, there was a constitutional convention, and the goal was to provide for a strong national government while retaining power for the states. So one of the primary goals of the Constitution is to set out a structure which will work nationally for certain types of things, and then leave other types of things to the states. And as I'll talk more about, the federal government's powers are what are known as enumerated powers. And what that means is the United States Constitution specifically sets out the powers that the federal government has. And those things which are not specifically given to the federal government are left to the states. So we're talking about the primary form of the Constitution, and then the amendments to the Constitution, many of which are enormously important. You'll probably have some familiarity with some of them. Among the ones that get discussed the most are the right to freedom of speech and freedom of religion in the First Amendment. What has been a huge and contentious issue in the United States is the Second Amendment of the Constitution sets out the right to bear arms. And that is to have weapons, essentially guns. And there's a huge debate as to what exactly that means, as to whether or not that was intended for only people serving in the military, or whether the meaning was broader than that. The Fourth Amendment and the Sixth Amendment deal with criminal situations. The Fifth Amendment, among other things, deals with the right of the government to take private property for public use. The Seventh Amendment guarantees a jury trial. Those are probably the most significant of what's known as the Bill of Rights. So let's talk a little bit about what the constitutional plan of government is. It divides the government into three branches: an executive branch, a legislative branch, and a judicial branch. And Article 1 of the Constitution creates what's known as the legislative branch, which is Congress. That's the Senate of the United States, and it's the United States House of Representatives. And the structure is that each state in the country has 2 senators, but the number of representatives from each state is dependent upon the population of each state. So California has many senators. Wyoming has only, House of Representatives. Wyoming has only a very small number. Article 1 also enumerates the powers of Congress, the most important of which are to pass national laws, to distribute and determine the distribution of money. And in addition, Congress is given powers to carry out what is necessary and proper to do everything else that it's charged with. Article 2 of the Constitution establishes the executive branch, which creates the presidency and the vice presidency, and it sets forth their powers and duties and their qualifications and the term of office. And the key powers, again, are the ability to preside over the executive branch, to enforce federal law, to command the military, and to develop foreign policy for the nation. And Article 3, which we're going to spend a decent amount of time talking about, establishes the judicial branch. And it establishes the United States Supreme Court. It sets forth the powers for the federal judiciary as to how they can go about and interpret and apply federal law. Constitution, as I mentioned, also divides powers between the federal government and the individual state. So this was a compromise that was originally reached between the states and those who wanted a stronger federal government. And the idea is the states retain certain authority to regulate matters within their geographic boundaries. And these things can be very important areas. They include education. They include matters of family relations, marriage and divorce. They include overwhelmingly, crime prevention. And they regulate business matters. For example, corporate law in the United States is entirely state law. So you will not find, for reasons I'll talk about, you will not find the United States Supreme Court deciding matters that relate to corporate law. Those are all decided elsewhere. Part of the compromise was the federal government was given authority to exercise exclusive matters over things that impact the entire country, like money and what's called interstate commerce, which is business relations between the various states, the military defense. And in the event there is a conflict between state law and federal law, there's something called the Supremacy Clause, which says that federal law is supreme. So that's, the executive branch. Now, Congress is divided into two primary areas. It's got the United States Senate and has the United States House of Representatives. And in order to create federal law, both the Senate and the House of Representatives have to agree on a particular piece of legislation, and it has to be identical in its form. So there's shared responsibility for lawmaking, requires cooperation.
Your inside working? Yeah.
Once again, if you're not muted, please mute yourself. It also gives each chamber the ability to restrain the lawmaking power of the other chamber. So the House has control over what the Senate can do to some extent, and the Senate has control over what the House can do to some extent. Congress is also given the power to oversee operations of the executive branch. This has obviously been a huge issue in this country, and to what degree Congress ought to be overseeing what the executive branch, that is the presidency, has been doing, particularly in the last few years. Now, to be a member of the House of Representatives, you have to be at least 25 years old. You have to be a resident of the state that the individual represents, and you have to have been a citizen of the United States for 7 years. And each member is elected from a congressional district determined by basically apportioning the population of each state into districts of similar populations. So in Illinois, where we are, there are a slew of different congressional districts. I'm not sure exactly how many there are in Illinois, but there are quite a few. And we elect multiple Congress people. Okay. To make sure that this is in conformity with the population changes in the country every 10 years, there is a national census done to determine population. And based on that, the number of Congress people each state gets may grow or may shrink. People in Congress are elected for a 2-year term. And the person who is basically the leader of the House is known as the Speaker of the House. They are elected by members of the controlling party, as you all again may be aware, for a number of years. The Speaker was a Democrat named Nancy Pelosi, but as of just a few days ago, the Republicans are now the majority in the House of Representatives, and they went through a very long, lengthy, contentious process to elect a new Speaker. And the Speaker interprets and applies procedural rules. They appoint people to the various committees of Congress. Committees essentially do the substance of the work. They assign potential laws to committees for review. They schedule when things will be heard and voted on. And interestingly, the Speaker of the House is actually second in line to the presidency. So if something happens to the president, the first person to succeed the president would be the vice president. The person who would become president is the Speaker of the House. Now, also, which has been much in the news over recent years, is that the House has the power to impeach federal officials for misconduct. Impeachment is the accusation. It's the first step in the process by which a federal official can be removed. Then it will move on to the Senate, and the Senate will vote on it. Senators are elected from each state for a period of 6 years, as opposed to 2 years for members of the House of Representatives. As I mentioned, every state has 2 senators. Unlike the House, who's primarily concerned with the interest of the residents of their particular districts, senators are charged with being concerned with the interest of the nation as a whole. And to be a senator in the United States, you have to be at least 30 years old. You have to have been a citizen of the United States for 9 years, and you need to be a resident of the state from which you were elected. The Vice President of the United States serves as the presiding officer of the Senate. They do not vote unless there is a 50-50 tie on a vote, in which case they can cast the deciding vote. So the party that controls the presidency has the ability to break ties in the United States Congress. Now, as I mentioned, as a practical matter, Congress performs its most essential functions through committees. How does this work? Well, once a potential law has been introduced, what's known as a bill has been introduced to Congress, it's first assigned to an appropriate committee and possibly a subcommittee. The subcommittee, if it's there, will hold public hearings at which anyone can voice their opinion. After the hearings, the subcommittee votes on the bill, and if it rejects it, the bill stops right there. It goes no further. If it is accepted, it's then sent to the floor of the House of Representatives to be debated. And following the debate, the bill's voted on, and people can vote to approve a bill. They can vote to reject a bill. They can vote to send a bill back to a subcommittee for additional work, or they can vote to do what's called table the bill. And tabling a bill basically means essentially ignoring the bill, not moving forward on it. And it's essentially the equivalent of rejecting the bill. For approval in the House, all you need is a simple majority in the vote. For the Senate, approval is a bit more complicated. Before voting on a bill, the Senate has to first vote for what is known as cloture. And cloture is essentially the Senate agreeing to end discussion on the bill and move it forward to a vote. And in order for there to be cloture, 60% of the senators, 60 of the 100, have to vote for it. So while the simple majority is sufficient to pass the bill may never get to the point in the Senate where it can be voted upon unless there are 60 people who vote for cloture. So if both the United States House of Representatives and the Senate vote in favor of a bill, it's then sent to the President of the United States. The President can sign it, and if it does, it will become the law of the land. The President does not want to sign it. They can do what's called vetoing the bill. And if they do that, it can still become law because Congress is given the right to override the veto. Now, a simple majority was sufficient to pass the bill initially, but to override a presidential veto, it requires 2/3 of the House vote for both the House and for the Senate. All right, other things about Congress which are worth noting is, as I mentioned, the Constitution specifically enumerates certain congressional powers, and it implies others. And among the powers that are stipulated to are the power to tax people, the power to borrow money, also much in the news recently, as you may know, the power to regulate interstate commerce, commerce between the various states of the United States. And that includes promoting, protecting, and possibly prohibiting Congress. And this is a really big issue in the United States. Congress has the power to establish laws on the subject of bankruptcy or insolvency, as it's known in certain places. It has the power to coin money. It has the power to protect intellectual property. And intellectual property, of course, is a huge issue. It is essentially divided into 3 different areas, into patents, and patents grant to the holder an exclusive right to the manufacture or sale of the patent holder's art, machinery, composition, or invention, to use the language in the used typically. The duration of the patent varies a bit based on what the item is. Second category of intellectual property are copyrights, and they grant an author the exclusive right to reproduce, publish, or sell their creative work. And then there are trademarks, and trademarks are distinctive words, names, symbols, or devices of some kind that identify goods or services of an entity. Congress has the power to establish the federal court system. It has the power to declare war. It has the power to maintain an army and a navy. And it has the power to make all necessary and proper laws to execute its enumerated powers. So these are sometimes referred to as implied powers. Something is necessary to carry out an enumerated power. That also falls within the power of the federal government. Now, there are some limitations on what Congress can do. Congress cannot, for example, pass laws which make things relevant for things that happened in the past. They cannot tax states disproportionately. They cannot pass laws that favor one state over another. There are limitations on how they can spend money. All right, the executive branch, the president, let's talk about that a little bit. So the executive power is vested in the president. President has to be a natural born citizen, at least 35 years old. He's resided in the United States for the prior 14 years. And the president is responsible for a variety of things, including overseeing domestic policy, overseeing foreign policy, overseeing the military, overseeing the federal bureaucracy, which implements all federal programs. As for the vice president, the Constitution says very little bit about their powers. Now, there are currently 15 executive departments in the executive branch, and they oversee much of what happens in the country. And those 15 responsible for biotechnology, pesticides, farming, food supply, food production. Second is the Department of Commerce, and they're responsible for domestic trade and international trade. They are responsible for growth of the economy. They're responsible for technological innovation. And this also includes the United States Patent and Trademark Office. There is the Department of Defense, whose name is self-explanatory. It includes its responsibility for military security and for national defense. There's the Department of the Interior, which manages the nation's resources and parks. There is the Department of Education, which provides funding and initiatives for various educational programs. Now, as we're going to talk about certain types of things, there is authority given to both the federal government and the state government. Education is one of them. A lot of education is carried out locally. Some of the educational policy is determined nationally. There is the Department of Health and Human Services, and they're responsible for health programs. They're also responsible for what is known as Social Security. Social Security is part of the United States legal structure, which effectively requires people while they are working to pay money in. And then that money is used essentially to provide retirement benefits for people who are currently retired. And how much you pay in and how much you can ultimately draw out when you retire is determined by how much money you make. The most recent of these departments is the Department of Homeland Security, which sprung up after 9/11, deals with preventing terrorist attacks. There is the Department of Housing and Urban Development, which is widely known as HUD. Its focus basically is on housing, particularly for people of lower income, and it focuses on preventing discrimination in housing. There's the Department of Transportation, and this includes the Federal Aviation Administration, which governs all flying things in the United States, as well as the Federal Highway Administration, which deals with roads that cross state lines. There's the Department of Veteran Affairs, and that deals with medical and housing and financial services for people who had served in the United States military. There's the Department of Labor, and it enforces the health and safety laws that apply to workers. It provides what's known as unemployment insurance for people, where if you lose your job for a limited period of time, the government will pay you. Provides workers' compensation for people who are injured on the job. And again, it also protects against discrimination in employment. There's the Department of State, which is responsible primarily for international relations. There's the Department of the Treasury, which is effectively the government's banker. It also is what covers the tax scheme, brings in the taxes. There's the Department of Justice, and the Department of Justice is charged with representing the United States interests in legal affairs, and it provides legal advice to the president and to the secretaries of the other departments. Now, the head of the Justice Department is known as the Attorney General. The department also includes the Federal Bureau of Investigation, Immigration and Immigration and Naturalization Services, and the Drug Enforcement Agency. And finally, you've got the Department of Energy, which deals with basically energy sources and conservation of scarce resources. All right. So as lawyers, we're concerned with all of that, but maybe the thing that concerns us most is the judicial branch. And the judicial branch is governed in Article 3. So at the time the Constitution was written, every state already had its own judicial system. And there was a lot of debate about whether the federal government, and if so, what the relationship between those systems would be. Those who favored a federal system thought it was necessary because state courts would not uniformly apply federal law. And ultimately, a compromise was reached whereby states retained their own court system and a separate federal system was created. So each has areas of jurisdiction, although there's overlap. State courts are known as courts of general subject matter jurisdiction. And what that means is any type of case can be brought in a state court. They're general subject matter. They can hear any dispute. Federal courts, by contrast, are known as courts of limited subject matter jurisdiction. There are only certain types of things that can be brought into federal court. And they include issues which arise pursuant to a federal law, and also what are known as diversity cases or diversity jurisdiction. And these are cases where the litigants are citizens of different states, and there is a certain statutorily determined amount of money at stake, an amount which is determined by Congress. It changes periodically. They raise the dollar figure. So Article 3 says Supreme Court, and Article 1, Section 8 of the Constitution creates lower federal courts. Now, the federal court system is sort of like the state court system, which we'll talk about in a second. It's consisting of multiple levels of courts. So at the top of the pyramid is the United States Supreme Court. And there are currently 9 justices on the United States Supreme Court. And the United States Supreme Court is the final arbiter of issues that relate to federal law. Now, the United States Supreme Court has what's referred to as a discretionary docket to the most part. And what that means is that most of the cases the United States Supreme Court hears are cases it selects to hear. There are some small category of cases where the United States Supreme Court is obligated to hear the case. If a federal law has been overturned by a lower court, the United States Supreme Court will hear it. But overwhelmingly, what the United States Supreme Court hears are cases that it thinks are important cases. So if a litigant loses at the court level just below the US Supreme Court, the Federal Court of Appeals, it can file in the United States Supreme Court something known as a writ of certiorari. And a writ of certiorari is basically a request to the United States Supreme Court that they hear the case. And there are a huge number of cases each year where people ask for writs of certiorari, and a very small number of them are granted. Typically, the docket of the US Supreme Court varies year to year. Typically, they hear about 150 to 175 cases in a year. Far more of that. People ask for certiorari. Now, one of the things you should be aware of, and one of the things which, much to my amazement, the American press still continues to get wrong, is if the Supreme Court denies certiorari, they are not saying that the lower court got it right. What they are saying is that the case isn't important enough for them to hear. There are a limited number of cases they can hear, and they're going to hear the ones that they think are the most significant to have a ruling from the United States Supreme Court. Now, the one category of cases where certiorari have done what's called splitting on the issue. That is, the Federal Court of Appeals based in New York City, for example, has decided the same case differently than the Federal Court of Appeals in California. And if there's what's called a split of the circuits, it's very likely that the US Supreme Court will grant certiorari and hear the case. But once again, denying certiorari does not mean the Supreme Court is saying that it was properly decided below. Denying certiorari means that they're saying this just is not one of these cases that's important enough for us to hear. Underneath the US Supreme Court, there are multiple levels of the federal judiciary. There are, starting with trial courts, the United States District Courts, and there are a lot of United States District Courts, and they try cases. Above the United States District Court are the United States Court of Appeals. And as was mentioned at the outset in the introduction, I actually clerked for, a year after I graduated from law school, I worked for a judge on the United States Court of Appeals. There are 13 courts of appeals in the United States. They cover multiple states. So for example, I am in Chicago in the state of Illinois, and we are in the United States Court of Appeals for the 7th Circuit. And the 7th Circuit includes Illinois, it includes Indiana, and it includes Wisconsin. So federal district cases that come out of those 3 states will be appealed up to the United States Court of Appeals for the 7th Circuit. The most significant of the Court of Appeals are probably the US Court of Appeals for the 2nd Circuit, which holds as New York and Connecticut primarily, and the United States Court of Appeals for the 9th Circuit, which covers the West Coast, including California. In addition to which, there is a separate United States Court of Appeals for just the District of Columbia. It is known as the DC Circuit. And it probably, of all the Court of Appeals, actually is the most significant. Quite a few Supreme Court justices had previously been justices on the United States Court of Appeals for the District of Columbia Circuit, although certainly not all of them. Underneath the federal district courts, there are 2 other levels of courts which are worth mentioning. The first are United States bankruptcy courts. And United States bankruptcy courts hear decisions on the subject of bankruptcy and insolvency. Now, in the United States, unlike basically every place else that I'm aware, there is a split in terms of how these terms are defined, which is different than elsewhere. Most countries, bankruptcy refers to the insolvency of an individual, and insolvency refers to the bankruptcy of a business. And it's common that there'll be a separate bankruptcy law to deal with individuals, and there will be a separate law written into the corporate statutes, which deals with business insolvency. In the United States, as I mentioned sort of in passing briefly, the Constitution gives Congress the right to pass laws on the subject of bankruptcy. And so Congress has passed one single law, the United States Bankruptcy Code. And the United States Bankruptcy Code applies to both individual insolvency situations and business insolvency situations. In addition to which, there are federal magistrates. And federal magistrates operate a lot like the United States District Court judges do, but they're a level down. So the United States District Court will often refer things to be determined by magistrate courts. Now, the United States Supreme Court justices, the judges on the United States Court of Appeals, and the judges on the United States District Courts are referred to as Article III judges. And what that means is to be put on the bench, they need to be appointed by the President of the United States, and they need to be confirmed by the Senate. And of course, this has on various times been a huge issue as to whether or not the Senate would confirm presidential appointments, most recently with Justice Kavanaugh. But it's also true for people who are on the United States Court of Appeals and people who sit on United States District Courts. They're all Article III judges. They all need to be appointed by the President. They all need to then be confirmed by the Senate. As a practical matter for the lower courts, it is often the senators from a particular state who are instrumental in determining who will be nominated to the federal bench. Now, for the United States bankruptcy courts and for federal magistrates, oh, and I should say, by the way, that Article III judges have life tenure. Once they're put on the court, unless their behavior is bad and they're eventually impeached, removed, they serve for life. Now, there are also what are known as Article I judges, and they are put on the court under the executive power under Article I. This is where United States bankruptcy courts fit in. This is where federal magistrates fit in. This is essentially a merit selection process typically done by the United States Court of Appeals. There is also a United States Court of International Trade, which is based in New York. And there is a federal appeals court that deals specifically with issues that relate to international trade that have come out of that court. Our law school happens to have a very long-standing relationship with the Court of International Trade. Every year we do a conference on international trade in April, and we have one of the sitting judges be the primary keynote speaker. And then we bring in a bunch of very prominent practitioners, lawyers, to talk about the issues that have been raised. If you're interested, I can certainly get the information to Marco once we have all the information set. It's typically in the middle of April, but it's a very interesting lecture. So if you're interested in issues that relate to trade, including trade between our countries, it's often a very interesting program. Okay, so that's the federal judiciary. In addition to which, every state has its own judiciary. And the structure of the state judiciary is very much like the structure of the federal judiciary. There is a state trial court, there is a state appellate level court, and there is a state Supreme Court. Now, the states are the highest arbiters of state law. So for example, if somebody brings a lawsuit under the Illinois Constitution, it will never reach the United States Supreme Court. In the state of Illinois, a state court, there'll be an automatic right of appeal to the appellate level in Illinois. But then the entity that decides the meaning of this, the ultimate meaning of it, will be the Illinois Supreme Court. So the US Supreme Court hears things that deal with federal law, and things that deal with state law are determined locally. Now, the structure of both systems essentially has set up the trial courts as being the fact-finding entities. So issues of fact are determined at trial. And if something goes up on appeal, they will be looking at the legal issues, not the trial issues. And in fact, if there is a factual issue that needs to be resolved and hasn't been, The appellate court will not resolve that issue. It'll be sent back to the fact finder, which is the trial court. So on appeal, an appellate court can either affirm a decision, say the lower court got it right. They can reverse a decision, saying the lower court got it wrong, or they can do what's called remand a decision. And remanding a decision basically says we're sending it back to the lower court for the lower court to determine certain factual matters that we need to know in order to resolve this case. Now, in both the federal system and the state system, if there are no disputed material facts, party can ask for what's known as summary judgment. Summary judgment basically is asking the judge at trial to decide the issue on the matter of law because there are no disputes in fact. So if anything, parties disagree about anything, there can't be summary judgment. But if the parties do what's called stipulating to the facts, they say, we agree on everything that happened, we just don't agree on what this means legally, it can go directly to the judge to decide it on a matter of law. All right, so that's the basic structure of the judicial system. And the Constitution, which I've mentioned, has been amended 27 times. Is something that we see litigated all the time. These tend to be the things that are very high profile. And among the issues that we tend to see litigated deal with the question of what the actual structure of power between the federal government and the states is. And this, of course, was the issue and has been the issue for a very long time in the issue related to abortion in the case that was decided a while ago. Right, this said that the federal government has enumerated powers. The Constitution tells us what the powers of the federal government are. And when the Constitution was written in 1787, it said nothing about a right to abortion for obvious reasons. So if the Constitution doesn't stipulate that the federal government has responsibility for it, the powers go with the state. Now, the question is, and this has been the question in many, many different areas, is do we read the Constitution as the original drafters of the Constitution 200 plus years ago meant it? Or is the Constitution what's often referred to as a living document? Has it evolved and changed? And do we have to read it in a way which gives sensible meaning to what's there in light of the realities of life in 2000, I was about to say 2022, but I should say 2023, all right? And so this was the issue. The Constitution doesn't say anything about a right to abortion. And because it doesn't, there's an argument that it should be left to the states. And that's essentially what the Supreme Court did. And when Roe versus Wade was decided, 1973, it said, it's true, the Constitution doesn't expressly say anything about the right to abortion, but the right to abortion is included within areas that the Constitution does speak about. When we talk about things like privacy, that includes the right to abortion. So these are issues which get litigated a great deal. What does the Constitution specifically say? And does it mean more than what it specifically says? All right, let me just talk a little bit about legal practice in the United States and about legal education. And then I think I'll talk a few minutes about federalism and a little bit about one of the big areas where federalism gets implicated, and then see what kind of questions you have. So that's sort of broadly an introduction to the legal system. All right, lawyers in the United States more or less are split into two categories. I guess you could divide them in different ways. Maybe you divide them into criminal lawyers and civil lawyers as well. But essentially we have transactional lawyers who are people who put transactions together. And these can be all sorts of things. They can create deals between corporations. They can arrange for loans between banks. They can write wills. And then we have litigators. And litigators are the people who wind up, basically fighting over these transactions if something goes wrong. And litigators are the ones who you see on TV and Law and Order and everything else. And the litigation process is kind of a very lengthy process. It includes, among other things, what's known as broadly as discovery. Discovery is the ability of the parties to the litigation to basically gather relevant information. And that includes asking people to sit for what are known as depositions. And a deposition essentially is a time when a person who is a relevant party to a case has to sit and answer questions truthfully under oath about the case. So before the case winds up in court, a great deal of background things are done, including discussions about settlement during the discovery process. All right, so in addition, a couple other things I should mention. Let me mention that there are uniform laws in the country, and uniform laws vary a little bit, but maybe the most significant of them, which is something that I deal quite a bit, is what's known as the Uniform Commercial Code. So the Uniform Commercial Code is actually not in and of itself a law. What it is it is a proposed uniform law to deal with all commercial transactions. And it is only a law because all 50 states have enacted it. So this happens in certain instances where something is drafted as a proposal, where it's important to have a uniform approach, and then the states determine whether or not they want to sign on. So the UCC deals with, among other things, various issues that relate to sales, issues that relate to contracts, issues that relate to what's called secured lending, borrowing money for various reasons. It's something I work with a lot in my own practice, and it's something which matters a great deal when you're talking about international transactions, because while the UCC does not typically govern, it doesn't govern at all when you're talking about international transactions unless the parties choose to make it the relevant law. Its importance is such that people recognize it and rely on it and make reference to it frequently when you're talking about individual types of business transactions. So I gather that there's sort of a mix of lawyers and law students who are on the call. So let me just give you a brief idea of what law students in the United States do. As you know, probably, that our students are graduate students. They did not major in law as undergraduates. And the legal program is an additional 3-year program post-college. And it covers a wide variety of things, deals with what are known as common law issues, much of the United States law in certain areas in particular, such as property law, the law of torts, law of contracts, goes way back to England. Now, other parts of the United States law have no connection with England. For example, when the bankruptcy laws were drafted, in England, you could be put to death for owing money. And so Congress wanted to distance the United States bankruptcy laws as much as possible from the English common law. But for a lot of things, there was a strong reliance on what happened hundreds of years ago in England and as things developed. So typically students in their first semester take sort of big common law courses. They take property, they take contracts, they take torts, which deals with non-criminal wrongs. They take criminal law. And then upper class, they have a variety of different things that they can take. Often people take sort of a core group of classes for things that touch on everything, like classes in commercial law, classes in taxes and evidence, classes in evidence, things everybody should know. And then there are far more specialized classes depending on what people's interests are. The law in the United States is sort of evolving in terms of how it's taught. Historically, it was taught according to something known as, time ago, there was a guy who was the dean of the Harvard Law School. His name was Christopher Columbus Langdell. And Dean Langdell thought that the way you learn law was the way doctors presumably learn about medicine, which is if you see a whole bunch of patients and they all have the same symptoms, it helps you kind of figure out what's going on and what the illness is. So his idea was that the equivalent of that in law was that law students would read very large numbers of cases. And by reading all these cases, they would be able to discern the common elements that led to the development of where, sort of what the law is. This has changed a lot over the years. Now it is much more, teaching law in the United States is much more based on problems, thinking through problems from the position of a lawyer, what lawyers need to know, what they don't know, how they go about finding what they need to know, things along those lines. And it's much more what's called experiential. There's much more emphasis on practical applications. Our law school has a bunch of clinics and lawyers of existing lawyers, and they're able to essentially practice law with a lawyer looking over their shoulder as a way of helping them learn. Okay, why don't I pause for a minute? I've been talking for a while, and I know there are questions that have come in the chat, and I also know I haven't seen most of them if they've come in. So and I think some of them may be in Spanish, and I do not speak a word of Spanish. So let me see if I can take a look at the chat and see if I can cover some of these, and then we can talk for a few more minutes.
Do you want me to read the questions?
That would be wonderful. And if you can translate the ones in Spanish, I'd be happy to take a quick answer.
Well, the first one is, could we say that if it is not stated by the Constitution, like abortion, it could be considered as part of the human rights reference, such as privacy?
Yeah. Well, that is in fact the exact issue. Yeah, I mean, that's the question is, the Constitution is a relatively short document, and it was written hundreds of years ago, and it doesn't set out rules to deal with the countless things that they never imagined could happen now. It talks in very broad, sweeping terms. People are entitled to privacy. People are entitled to due process of law. People are required for, should be given equal protection of the laws, things like that. So the history of constitutional law in this country, to a large extent, has been exactly that question. It's been fleshing out, what do we mean by privacy? Does that include, for example, and so that's, it fits in exactly with the issues of privacy. And Justice Blackmun, when he wrote Roe versus Wade all these years ago, famously used a word which probably most people hadn't heard until he used it. And he said the right to abortion is found in the penumbras of the Constitution. And penumbra sort of means kind of little offshoots that aren't self-evident. So he said the Constitution doesn't specifically say there's a right to abortion, but included in the rights that it does stipulate are various other rights, and it included the right to abortion. Now, the current Supreme Court, as you all know, has said the opposite and said that this is not something which is governed by the Constitution. And they didn't say abortion is illegal in the United States. What they did was they said this is one of these areas that's not given to the federal government. Because it has not been given to the federal government, we're going to send it back to the individual states to decide state by state whether or not it should be legal. So if the US Supreme Court said that the United States Constitution mandates legal opportunity to have an abortion, no state could rule otherwise, because the supremacy clause, what the US Constitution says, is the final ultimate arbiter. But if the US Supreme Court says that the Constitution doesn't rule on this, then it goes back to the states, and that's where we are now. And that's why we're in this situation where there are all sorts of different laws in different states that deal with this issue. And it has created, very, 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 very strong feelings in the United States for people on both sides of the issue. And again, it really goes back to what we mean by, what do we mean to interpret the Constitution? Now, just to sort of expand on this just a little bit more, Justice Scalia, the late Justice Scalia, made the argument that if we do not look at what the framers of the Constitution meant when they drafted the Constitution, then it's just 9 people in Washington giving their own opinions. So the only sensible way to give meaning to what's in the Constitution, so it's not just the 9 people who happen to currently sit on the Supreme Court saying what they think, is to look at what was drafted and meant at the time it was drafted. Now, a lot of people disagree with that. And the reasons for disagreeing it, again, I've mentioned, and they're quite self-evident. The world in 2023 does not look like the world looked in 1787. And whatever they were thinking back in 1787, and we can't know exactly what they're thinking, although they're contemporaneous writings that give some suggestion, certainly they had no notion of things that were going to pop up in the world over the next 230 years, 240 years. And so limiting what's in the Constitution to things that happened or were relevant so long ago, according to the argument on the other side, is just absurd. And the Constitution has to evolve. And what we mean by privacy in the 18th century is not what we mean by privacy in the 21st century. And we need to take that into account. So that hopefully that answers the question. You want to read the next one or?
Yes, sure. Thank you. What are the characteristics that the U.S. can learn from Mexican government and vice versa?
Really good question. As for the first half, I am afraid I know very little about the Mexican governmental structure, right? Most of the work, although I do international and comparative stuff, overwhelmingly the stuff that I've done has actually been in Europe and to some extent in South America and Australia. So I know very little about the system in Mexico, and it's something which I'd like to learn something about. Nor interestingly, I know very much about the system in Canada either. My work has been elsewhere largely. In terms of what you can learn from the United States, it depends obviously sort of on what the law in Mexico is like at the moment. Like every other structure of government, I gather, we have positives and we have negatives. And we sort of go back and forth amongst them. So, there are times when things seem to be running more smoothly, and times that things seem to be running, and with more difficulty. I have to admit, and this is a statement of my personal feeling, there is a lot that is going on now in the United States, which 15 years ago, I would have thought was absolutely unimaginable that it could ever happen. The most obvious, ready illustration of it is what happened last January 6th. Not last January 6th, the previous January 6th, right, 2021. And the follow-up from that, it's so our government is in a huge, huge state of transition. And a lot of things that people used to look to the United States for things that are positive, have undergone a very radical change. For a long time, the United States perceived itself, rightly or wrongly, as being among the leaders in the world for protecting human rights and for a forefront in dealing with climate change and a variety of other things. And during the time between 2016 and 2020, much of that changed in a very dramatic way, beginning with one of the first things that Donald Trump did when he became president was announcing that he was pulling out of the Paris Climate Agreement. So, we're in a state of transition. There certainly are a lot of things in the United States government in structure of justice, which are worth looking at. And to a large extent, I think much of the world still does. I mentioned before the Uniform Commercial Code. And I deal with international business transactions. And again, they're not governed specifically by American law, but American law is so prominent and people basically think it's so well done in certain instances that it often forms the backdrop of a lot of negotiations. So, we do some things really well. We do some things really badly. And, we're in kind of transition from having done things well to badly and maybe back again, sort of an ongoing process. So I would be interested in hearing, I'm sure we have time today, but I would really be interested in learning about the Mexican system of justice and about things that, you all think that we can learn from Mexico. And when I have a little better sense about what the structure is like in Mexico, perhaps I could answer the question a little bit better. But more broadly, again, I think our basic structure of government works well on the whole. But there are holes in our structure of government that we discovered, in 2020 that people didn't think were there. And there are a lot of things that need to be fixed.
Okay, thank you. The next question, why to make new constitution instead of interpreting all the rights of what was written 200 years ago? Is it because of the authority that the Bill of Rights has?
Yeah, it's a good question. The Constitution can and has been amended. I mentioned all the different amendments. So, there's never been a discussion. The Constitution has always been viewed as being kind of sacrosanct. This was the supreme law of the land and nothing would change it. But people recognize the ability or the need to amend it and change it. And it has been in a variety of different ways. The most famous are the Bill of Rights, which were done almost immediately. But for example, there was 100 years ago, women in the United States were given by constitutional amendment the right to vote. So it can be amended. I don't think there's any possibility it will be rewritten. The problem is, there are two problems. One is the process of amending the Constitution is difficult, very difficult. And it's happened only when there's an obvious kind of extreme need to do it. And secondly, our government right now is so incredibly polarized that I don't see there's any possibility it could happen. I mean, there was a time in my lifetime, I remember, when the Democratic Party and the Republican Party actually tried to work together to benefit the United States rather than just to try to seize power, stop the other party in power from doing things and seizing power themselves. But that seems to be the purpose of the people who are in government now. They seem far less interested in doing what's right for the country than in trying to push their own, ability to get power back to push their own particular agenda. And amending the Constitution would require everybody who is in Congress, basically, or a large percentage of them, agreeing to make a change. Well, I guess there's a possibility that that could happen in certain areas. Doesn't seem very likely. So my guess is we're not going to, it's been a long time since we've seen an amendment. I don't see it happening anytime soon. I think the fight is just going to be, what do we do with what we have? But again, I mean, I can't even remember until a couple of weeks ago, where somebody who I won't name suggested that perhaps we should not be paying much attention to the Constitution. It's always just been considered something that was beyond discussion, that the Constitution is the supreme law of the land. A country is based on it, and at its core, it is a good and valuable document. So I don't see it being rewritten, but it's going to have, it's going to leave this endless debate about its meaning and interpretation. And this is what constitutional lawyers deal with all the time. One of the things about what I like about what I do is that the laws are much clearer and much more concrete. I mean, there actually are clear laws in the business world. And if I'm doing a transaction, I know exactly what I'm dealing with. Where when you're dealing with the Constitution, I mean, you are much more than it would be optimal at the whim of certain people who are temporarily empowered to determine its meaning and its application. And to me, constitutional law is very frustrating as a result because of that. Okay, were there other questions as well?
No, I don't think so. Well, I guess that's all for today.
Okay. Does anybody else want to ask anything? Okay, how are we doing with time? I'm not sure how long we were supposed to run for today. We have a few more minutes, or do we not?
I think all comments are about thanking you for the expositions.
Okay.
But no, there are no more questions.
Okay. No, I was happy to do it. And I can give you, I think somebody might have asked, I think I saw this flash up, if there's a way of contacting me. And absolutely, you're certainly welcome to email me. My email address, which perhaps you can put in the chat, is plewis, Lewis 8 at uic.edu. plewis8 at uic.edu. And I'd be happy if you have questions that you've thought of, in the interim about what I've said, or would like to know about things that I haven't said that I can help you with, I'd be very happy to discuss them with you. And again, I'm very excited about, this developing relationship between the universities, and I hope that we'll be bringing students to people and lawyers to Chicago to study things that are of specific interest to you in a more detailed fashion, and hopefully getting some of our students to Mexico to do the same. I look forward to having these discussions in the coming weeks and months about how we can best do that. But I was very happy to do this kind of broad overview today. And if there are no last questions, maybe at this point we'll stop. Somebody's hand's up. Yeah.
Well, thank you so much, Professor, for your time and the valuable information given in this lecture. It was a pleasure to have you here today. And thank you for the audience for accompanying us in today's meeting. Tomorrow's lecture will be about general aspects of the legal practice in the US. And see you there.
Okay, sounds good. Have a good rest of your day, everybody. Very nice to have a chance to talk to you. Okay.
Thank you.
Bye-bye.